And so it is with great pleasure that I introduce him today to talk about a topic that he has been working on for many years, and so I'm eager to hear the latest update on it. What happens in India when you get hurt? Indian tort law. Please help me welcome Professor Marc Galanter.
Thank you, Don, and thank all of you for coming. I know a tort law is the law of injuries, or things that injure you that are not connected with any contractual undertaking on your part. I think for simplicity's sake, think of it as the law of intrusions. Intrusions on your bodily integrity, on your reputation, on so on. And so tort law is usually divided into what we call the intentional torts, assault and battery, false imprisonment, libel and slander, and so on the one hand, and negligence on the other. That is where, without intention, someone does something that injures you. Until well into the 19th century, it was the intentional torts that were the really important, prominent parts of this field. But the introduction of machinery on a widespread scale, the invention of the railroad, and then the automobile reversed that. And now it's negligence that's the big topic, and the intentional torts are kind of peripheral. And basically what I'm going to be talking about is negligence. What happens when, due to somebody's carelessness or failure to take care, you get hurt in India, as many people do. Now, India has a tort law that sort of resembles that of England or our own. So if you look just on paper, it looks familiar, but in practice, it's very different. Now, one of the reasons it's different is that from the early days of British rule, the rulers of India thought Indians were excessively litigious. They were inclined to misuse any opportunity for legal remedy, to pursue status, to carry on feuds, and so forth. As one director of the East India Company said, this is back in 1832, the natives of these provinces, to whom the duel is little known, repair to our courts as to the listed field, where they may give vent to all their malignant passions. So that was the view that Indians are up to no good usually when they're litigating, and so we shouldn't increase the opportunities. In fact, to restrain litigiousness and, not incidentally, to raise considerable revenue, India's rulers imposed fees for using the civil courts. Not just a kind of a filing fee that we're familiar with, but an ad valorem, that is percentage-wise court fee. So if you ask for 1,000 rupees, you might have to buy stamps of, say, 10% of that and put on your complaint. So you could see that this would be a significant deterrent to using the courts to get money damages from someone else. But nevertheless, even with this kind of discouragement, the people did use the courts, and in the period from when court statistics start to be collected in 1880 up to the time of the Depression in 1930, there's a gradual but significant rise in the use of the courts by Indians on a kind of per capita basis. So, but very little, as far as we could tell, most of it, I mean, of course, there's lots of use of the intentional torts. There was a survey done back in 1970. Somebody looked back and said all the reported tort cases. Now, reported cases mean ones that went up on appeal and were decided by some top court, and its written opinion became part of the literature. So that's a very select, not necessarily representative group. But nevertheless, I looked at 50 years of reported cases, and there were just 613 reported tort cases. More than half of them were intentional torts. So we're really talking about the first half of the 20th century. 184 malicious prosecution cases, 73 defamation cases, and only 130 negligence cases. So for these 50-some years, there's about 11 cases a year printed that become part of the literature, but only 2 of them are negligence cases. So, and, you know, all the it's the intentional torts that had sort of gotten the bulk of the attention up till that time. As I say, there's an increasing level of use of the courts, rising to, well, you know, these are figures per million. But there were almost 10,000 cases per million in 1933, which was the high point. And then they plunged precipitously, so that by the time of independence, instead of 10,000, there were 3,800, and 20 years later, the rate was, in independent India now, the rate is less than half of that. So basically, the rate now is about 1/5 of the rate in 1881, and about 1/7 of the rate in 1933. This is the use of the regular courts. I mean, it's kind of, now, in addition to the regular courts, there are now a lot of tribunals and so forth. But my guess is that the total caseload of the tribunals is less than that of the courts. But even if it's the same or twice as much, we're still in a situation where we have much less use of these agencies than was the case in 1881, and much less than 1933. So whatever is going on, it's not a huge use of the courts. People tend to think, oh yes, you know, Indians use the courts a lot, but in part that's a perception that has to do with the fact that there are relatively few courts, sort of population basis, and the courts that there are, of course, are very congested, and not necessarily because so much is coming out, but a lot goes in, but not much comes out, and therefore the courts appear to be, or are in effect, very, very crowded. We can conclude that the rate of utilization or invocation of the courts in India is low on a comparative basis. It's in the range of such famously non-litigious populations as that of Japan or South Korea. And so the puzzle is, how can it be that so few Indians do invoke the courts, but there's a widespread perception that the courts are inundated with cases, that frivolous litigation is rife, that there's a great abundance of hungry lawyers, all of which may be true. So there's a relative scarcity of litigation on the one hand, and an impression that there's a great deal of it on the other. Well, partly this has to do, I think, with the fact that the Indian media like the American media, are saturated with news of court proceedings. These are almost all cases in the Supreme Court and the high courts which play an important political role and whose services are very much in demand. But few everyday matters like torts come before these courts. They're largely appellate courts. They do have an extensive original jurisdiction to hear matters involving violations of fundamental rights, but that's mostly that's mostly cases against the state. Ordinary matters like contracts, divorce, and torts, those reside in the district courts. And these district courts are desperately congested. India has, as I say, not enough courts. There's about 1/6 to 1/10 the number of courts that you would have in the more in the richer parts of the common law world, say the UK or Australia or the US. 1/6 to 1/10 on a per capita basis. And the courts that there are tend to be poorly equipped and inefficient. But apart from any physical and technical deficiencies, there are outmoded procedural laws that provide abundant scope for delaying tactics, which are used with great effect by many Indian lawyers. So cases tend to linger interminably, arrears mount. The lawyers who tend to be fiercely loyal to existing practices resist reforms by collective action, by wielding their street power. And one result of this is public disdain for these lower courts. The public has a low and generally, I think, realistic expectations about law, lawyers, and courts. Potential users forego the lower courts or avoid them wherever possible. Many from ignorance, perhaps, but most, I think, from calculation, that they know, you can't really get much here, and you can get yourself caught in a trap of endless expense in trying to use these courts. So the courts provide a useful facility for those who wish to avoid payment of taxes or postpone payment of taxes or debts, those who wish to forestall eviction or other legal action against them. So generally, they serve those who benefit from delay and the non-implementation of legal norms, parties who are satisfied with the status quo, either the status quo as it existed ex ante or after obtaining an interim order, and that is what we would call an injunction or stay. And a very large portion of all litigation in India ends with one party getting a stay, and then this sort of endless delay, and it goes on until somebody dies, and it can still continue to go on. Their descendants can keep the case going, and so on. But so there's because of the as one observer put it, defendants who have achieved preliminary injunctive relief benefit from the time value of money by refusing to settle, even in cases where they realize they are likely to lose. So, as another observer said, the honest litigant is impeded in the asserting of his legal rights, while paradoxically enough, the dishonest litigant is encouraged to assert unfounded or exaggerated claims. Or as one local banker confided to a journalist, we tell our clients to settle if they have a strong case and go to court if it's weak. Okay. So I should say a very large portion of all these cases involve government bodies. The government is a party in maybe more than half the cases in the courts, and is a very nasty litigant, which tends to pursue matters simply for delay, engages in relentless appeals even though knowing they have no merit or chance of winning, and so on. Anyway, so for those who require vindication or and prompt implementation of remedies and protections, women from husbands or relatives, laborers from landowners, citizens from government, the system works only haltingly, partially, and occasionally. So there's many meritorious claims are absent from the courts, and not surprisingly, the claims that are present include a significant portion that are frivolous in the sense of being brought or maintained for purposes of harassment or delay. And these patterns are consistent with a very low rate of tort litigation because the potential tort litigant claimant faces a daunting series of obstacles. Ad valorem court fees, continuing lawyer fees. India does not permit the contingency fee, which is it's common in the U.S. Where the lawyer basically takes the case and says, if when we recover, I keep a third of the recovery. That's considered unethical by the Indian bar. There is some of it done on a kind of an informal basis, but basically most Indian lawyers required to be paid usually in advance, and after lawyers tend to be paid by the appearance. So if a matter is called in court and the lawyer, engages for 5 minutes and then the case is put off, that's an appearance, and an appropriate fee, depending on the lawyer's status, is docked. And then when the amount that the lawyer has taken from the client is used up, he asks the client for a refresher, and the client has to put up some more money and so on. So it's a pay-as-you-go system for the client, and since cases can be delayed indefinitely, it's not a very promising way to go for the client. So court fees, lawyer fees, successive delays, interlocutory appeals. That interlocutory appeal, I mean an appeal, it doesn't mean the lower court has decided the case and now I'm going to appeal. It means the lower court has issued an order or refused a motion that you've made, and you say, I'm going to appeal that. We're not going to go to the end of the case, get a resolution, and then appeal it. We're going to appeal right here in the middle on that particular item, refusal to call a particular witness. There's a whole long list of things. And now, Indian law is very liberal with these interlocutory appeals, and you can see it was a colonial device. It was a way where Britishers at the top of the system could keep close watch on what the Indians at the bottom of the system were doing. So you allowed people to bring up these matters. Now, curiously, in independent India, nobody's said, well, let's get rid of all this stuff because, now we should have lower courts that we can trust. But that's where the lawyer's power comes in, because these are devices the lawyers can use and are used to using. It's an asset from their point of view, and so they won't let they won't let reformers come in and strip this away. As I say, the tort litigant or the potential tort litigant is sensibly discouraged by all of this and tends not to bring cases. So in this situation, most tort claims, that is, most suits for money damages, that is, you can ask for different things from a court. Typically, we think of, well, people go into court and they ask for damages. That isn't the case in India, because it's so hard to get money damages for anything that most of the cases are cases for what we would think of as kind of injunctive relief. It's trying to stop somebody from doing something, or to stop them from exercising their power as a trustee of a temple or whatever. That's the kind of litigation that really flourishes. First of all, because when you're asking for litigation, the court fees are nominal as opposed to the ad valorem fees when you ask for money damages. So it's much cheaper to use the courts for that. You don't have to make this big investment. And so people fight about this kind of thing. They don't use the courts usually to fight about getting you to pay me some money that I'm entitled to. So if tort law doesn't really connect with the ordinary run of individual injuries, has even less connection with mass disasters, which are not infrequent occurrence in India. It's hard to document a negative. I can only say that I've never heard of any instance of any industrial explosion, mine cave-in, building collapse, food adulteration, mass poisoning, or any other mass injury. And as you know, if you look at the newspapers in India, these things are happening all the time. I've never seen any that led to a tort claim. I can't say that. There have been one or two, but they have been uniformly unsuccessful. And if you look at the surveys of tort cases reported in the law reports in India, you don't see this kind of case. You see the typical cases. That the few cases that are there tend to be involve things like downed electrical line. Somebody got electrocuted by a downed electrical line, or railroad crossing accidents and so forth. The kind of stuff you would see in the American reports in the 1890s or the early 20th century. And you say, but India's an industrialized place. There's all this machinery. There's all these sophisticated industrial processes going on, but none of it ever shows up. So in December 1984, India had this, as I say, what I think of as a low-use, low-remedy, low-accountability system, which was in place. And then the system received this rude shock of the gas leak at the Union Carbide's plant in Bhopal, which killed thousands and injured many thousands more. And it was the shock to the system was not so much the vast scale of the disaster, but its transnational origin. Imagine if this had been a purely American event. I mean, actually, Union Carbide had a twin plant making the same methyl isocyanate at Institute, West Virginia. If instead of the undernourished twin at Bhopal, the West Virginia plant had been the one that exploded, you can readily envision a huge mass tort case, judicial improvisation of devices to handle it, very likely a settlement for a substantial amount, and even the resulting reorganization of Union Carbide through bankruptcy. It would have been a big, unwieldy case. It would have possibly strained the capacity of the courts, but it would have delivered significant compensation and broadcast very powerful preventive signals to many audiences. And actually, the Bhopal, in a curious way, because of the threat of American litigation, did generate powerful preventive effects. And the chemical industry largely reorganized in some ways the way it was going to handle accidents, warn surrounding communities, and so on. Anyway, in spite of the many imponderables, including problems of causation, uncertainty about the final toll of injury, this limited single event format would have presented a very good candidate for a more or less satisfactory resolution in the U.S. high cost, high accountability, high remedy system of private law. But now imagine the other, that it was a purely Indian event with a domestic Indian company in the role of Union Carbide. I conclude, on the basis of all previous experience, notwithstanding the vastly greater scale of this disaster, it's very unlikely that tort law would have been invoked at all. There would have been an ex gratia payment of compensation. That's typically what happens in big disasters in India. Sometimes the company, if it's a very substantial one, will announce that it's going to make ex gratia. If it's Tata or somebody, they say we're going to make an ex gratia payment of so and so much to everybody who's injured, and so much to the families of those who died, and so on. As I say, there would have been in my hypothetical all Indian Bhopal case, ex gratia payments, perhaps meager by Western standards. There would have been a commission of inquiry, very likely a criminal prosecution, and so on. And my support for this argument is that buildings collapse, mines cave in, hundreds are killed by poisonous liquor. There's a constant stream of these little Bhopals in India. For example, in December 1995, more than 500 persons, mostly children, were killed in a fire that swept through a temporary structure housing a school ceremony. Accounts stressed the inadequacy of safety measures and emergency services. The state government announced it would provide ex gratia payments of 100,000 rupees to the families of the dead and half of that to those seriously injured. So typically, the law, courts, and lawyers are not involved in establishing accountability or securing compensation. And so there's no reason to think that an all-Indian Bhopal disaster would have departed from that pattern. In the case of Bhopal, it was the American identity of the malefactor that coupled the disaster with the legal system in a way they would not have been connected otherwise. This perception of invasive violation and pollution by a foreign intruder generated a sense of shared injury and outrage. And at the same time, the American connection brought with it the image of an American tort system laden with both sting and largesse. And this was quickly given dramatic embodiment by the arrival in India of American plaintiffs' lawyers trying to sign up the victims just days after the explosion. But even before the American victims arrived, Indian officials were discussing the possibility of recovery in the United States at American levels of compensation. So this reach for an American remedy was the reverse side of a deep pessimism about a remedy in India, coupled with untroubled confidence in the U.S. legal system and anticipation of enormous recoveries. A few weeks after the gas leak, the Chief Justice of India said, "These cases must be pursued in the U.S. It is the only hope these unfortunate people have." So at first, the export of the legal action to the U.S. provoked hardly a murmur of dissent. Everybody said, yeah, let's do it in the U.S. So the government of India equipped itself with statutory authorization to be the exclusive representative of the victims, pursued the case in the U.S., but it sued in the U.S. that Union Carbide's counterattack was to say, no, this doesn't belong in the U.S. There's something called forum nonconvenience, that basically getting a court to declare that this is not the appropriate forum, that there's an alternative appropriate forum, in this case India, that would be better, and to send the case there. And indeed, after some skirmishing here, the case was sent back to India. There was a year or so of inconclusive grappling. The Bhopal District Court ordered interim relief. This led to an interlocutory appeal to the, I should say interim relief in a tort case is very unusual, but possible. And anyway, the matter got up to the Supreme Court of India, and at that moment, with the case in the Supreme Court on this preliminary matter, the government of India concluded a settlement with Union Carbide, which was immediately endorsed by the Supreme Court. And the government and many observers, including some in the judiciary, justified this settlement as beneficial to the victims by comparing it with the results of further litigation that, according to the government, would have lasted anywhere from 15 to 25 more years. Now, here's, in some sense, the proprietor of the legal system, the government, saying, this would take 15 to 25 years. And so it was an assertion that there was an unalterable character to the legal system that made it inevitable that we couldn't get a result before the passage of so long a time that the discounted present value of the claims was less than the amount that would be delivered under the settlement. So that is, the features of the system that ensured protracted delay were treated as given and unchangeable. And so the amount was handed over, and it turned out it did take from 15 to 25 years, in spite of the fact that the case was settled. The distribution of the settlement funds by the government was quite niggardly and inefficient. As one authoritative report said, no claim was settled earlier than a waiting period of 7 years. The adjudicatory process involved over 5 visits of 2 hours each for the claimant, but ultimately the judge was able to spend no more than 10 minutes on a case. After 20 years, the government still had, because the money, which was in dollars, was earning interest all the time, the government retained an amount roughly equivalent to the amount it had already distributed. And in 2004, that's 20 years after the accident, the Supreme Court ordered the government to distribute the remaining funds pro rata to all the prior recipients and just get rid of it. Now, I should say that, like other observers, I expected big changes in the wake of Bhopal that would usher in a new era of tort for India, but no such changes have occurred. There were a few doctrinal innovations that were stimulated, but they didn't really inspire reforms that dislodged this low-use, low-accountability, low-remedy system. And as a result, well, you could say few are inspired in India to take on the Sisyphean task of an overall revamping of the civil justice system. Advocates and activists are much more likely to seek a bypass for whatever constituency they're concerned about, whether it's the people in the consumer movement or the banks that want to just collect debts more efficiently. Everybody comes in and says, give us a tribunal, give us a bypass around the system. And so you get this great multiplication of tribunals and still very little use. And the tribunals, after a while, tend to become similarly congested and backlogged, and kind of resemble the situation in the courts. So there's some significant cultural patterning here that cannot be avoided just by creating a tribunal. I really want to leave a little time for discussion. We go to 1, is that the idea? Okay, so let me just quickly conclude by saying, as I say, there's no foundation really for the widespread belief that India is a highly litigious place. It's interesting that belief coexists among educated urban Indians with the notion that decent people have as little as possible to do with the courts. We're told that, as in Japan, people will say, oh, we avoid the courts because we have a cultural distaste for suing. So I think this anti-litigation story is a misreading of the Indian scene. There's evidently, it seems to me, there's an evident demand or appetite for tort recovery, but it doesn't manifest itself in what, for Americans, seems the heartland of tort, the claims against private parties for negligent behavior. But wherever there's access to any usable procedure, as in the motor accident claims tribunals, the consumer tribunals, which are now used for medical malpractice claims, in the high courts where people try to use the writ jurisdiction, the ability of the high courts to take up something directly, and people try to use some very clever ploys have been used to try to move tort cases into the high courts. And there's a quite spectacular example in Delhi in 1997. There was a terrible theater fire in the Upar Theater, and 50-some people were killed. These were sort of affluent Delhiites, and they organized, the families organized, and a very capable volunteer lawyer handled the case for them, and they sort of managed to get into the high court directly, because I could explain that, but I don't want to hold things up. But the case is still going on. And just after getting a very significant recovery against both the theater owners and the government officials who had failed to apply the licensing laws to the theater and so on. But just a month or so ago, the Supreme Court lowered the amounts very significantly, which brings back this sense of that there's another cultural thing, that people are very, very reluctant to see anybody else get a windfall. There's a real, the judges are very worried about this, and so, but I'll come back to that. But anyway, as I say, wherever there's any usable procedure, people do make claims, and sometimes the courts are responsive and inventive in meeting those claims. So the district courts, as I say, the ordinary courts are not a viable forum, so the action is in tribunals, in using the writ jurisdiction in the high courts, in the realm of ex gratia payments, and with some spillover into the criminal process, which is another part of the story. And because this history of high court fees has meant that if you have a grievance against somebody, and you think they owe you some money, if you can use the criminal process to go after them, it doesn't cost you anything. The government bears all and not only do you avoid the court fees, but you don't have to pay a lawyer. So there's a lot of tendency to use the criminal process to pursue civil claims. Anyway, so as I say, one theme that seems consistent is a great appetite for action to punish intentional incursions on one's dignity or well-being. We saw that pre-independence predominance of the intentional torts, and in some sense, it seems to me that theme is still there. And this compensation need not be in the form of mulcting the wrongdoer or injurer. Responsibility is frequently based on ability to pay and the duty to care for one's dependents, rather than necessarily entitlement growing out of wrongdoing. So the connection between accidental wrongdoing on the one hand and compensation on the other is not really very firm. There's very little interest in facilitating recovery on a routine basis. So in conclusion, I would say tort in India resembles a kind of river whose main channel is dammed up by forbidding obstacles. But the force of the stream finds other channels. So you have this kind of vast, intricate delta in which tort recovery in ordinary negligence cases in the regular courts is obstructed by delay and expense. But the demand for recovery and punishment seeks out new forms and new procedures. And in this setting of booming economic activity and rising expectations, the question is whether the main channel can be dredged, or which of the new channels will become stabilized and able to handle heavy traffic, and how they will connect with one another. So I want to leave it there and use our remaining time. Let's see what kind of questions or observations you have. Joe.
Given that there seems to be this whole delta of alternatives,
Yeah.
is there any group in India, lawyers or an NGO, that is eager and trying to set up something that works? Or is it just so many other things working that it's not going to get anywhere?
Well, I mean, as I say, people say we want something that works for this constituency within our lifetimes, then we're not going to take on reforming the whole system. We're going to go and say, and you know, it seemed to me the consumer movement is a great example. You had an active consumer movement, and they didn't say, you know, let's, you know, we want to be able to use the courts and let's reform the courts. They said, we want a consumer tribunal. And a whole network, nationwide hierarchy of consumer tribunals is in place. And you know, many of these torts, particularly medical malpractice, is now, which has been on the books in India forever, but has been rarely pursued because of the obstacles that I mentioned to tort recovery. So now there are a considerable number of medical malpractice claims being pursued in the consumer tribunals. So there are constituencies, but as I say, every constituency comes along and it says, this whole thing is vast. It takes many lifetimes of effort to deal with the whole thing, and you know. So give us a tribunal to deal with our problem. And so there's this great proliferation of tribunals. And some of them work for a while, and then you know they tend to get jammed up like the others, because in almost all cases there are appeals from the tribunals. You know, you can go through the hierarchy of tribunals, and then you get an appeal to the courts. So the courts can be used in some sense as an obstacle or a counter to any effectiveness in the tribunals. Yeah.
Professor was wondering whether people are non-litigious in tort because also it's unwritten law mostly.
Because what?
It's unwritten law in India, mostly tort law.
Well, unwritten in the sense that it's not codified. You're absolutely right that when after the 1857 revolt, the British government took over the interior of India from the East India Company, and now they're going to have a unified legal system. There had been separate legal kind of British law in the three presidency towns, and then in the vast interior area run by the East India Company, there was just the company's kind of simulacrum of English law. I mean, it was the law was justice, equity, and good conscience, but since it was being administered by Britishers, they basically thought, well, that must be the law of England, right? So the law of England, it was in effect the law. So they said, okay, the law of England's pretty unwieldy. If we're going to have a nationwide legal system, we're going to codify it. And the utilitarians had been pressing, and there was a kind of there were a number of utilitarians involved in the administration of India, and there had been this pressure for codification. So they, between 1860 and about 1890, every field of law except the personal laws and torts was codified. And there was actually was a draft code of torts, but in the end, the politics of it was they didn't. But you know, it's still written law in the sense that there are all these written decisions which basically form the law of tort. So it's not unwritten law, but it's uncodified law. And of course, what happened with the codes, which were originally, the British brought in these codes and they thought, we will not have a common law system of case law, so that in order to look something up, you have to have a huge library and read a whole bunch of cases. Instead, we're going to have a nice little statutory provision, and we'll be able to read it, and maybe we'll even have some examples given. They would put examples in some of the codes. But it turned out that what happened is that these codes became like a trellis on which you got all this common law adjudication, building up interpretations of the law and so forth. So you have basically a common law system, as I say, but if you sort of, it's organized on this sort of trellis or framework of these codes, of these 19th century codes. But for any say American or British or Australian lawyer going there, it's very readily recognizable as a common law system, and all you have to do is learn that you have to look things up by knowing which code section it might be involved. Anyway, so I'm not sure, you know, that the uncodified character can explain the absence of tort consciousness, because it's interesting that the parts of tort that were very popular in the late 19th and early 20th century, defamation, libel, malicious prosecution, these intentional torts, they were uncodified too. But people used them because they were worthwhile. They gave you very good value in carrying on your feuds with other people. You could, so those parts of the law of torts were used. Less so now, but there's still, probably more malicious prosecution cases and false imprisonment cases in India than probably in the rest of the common law world put together. In spite of the fact that, the rate of negligence cases is much, much lower. Yeah.
So what does happen in India if you get hurt? Let's say you're riding your bike and a car runs into you.
Well, if it's a car under the motor vehicles, there's a motor vehicles tribunal. You can go to the court. And actually, if let's say you're in Meerut or someplace, not a big city, and you would go to the district court, and file, and that court would also sit as the motor vehicles tribunal. So the district judge, if it's a small enough place and they don't have a separate person, will also be the chair of the motor vehicles tribunal. And you would file a case there, and motor vehicles, there's a kind of you can claim up to a certain amount on a no-fault basis where you don't have to prove fault, and then if you want to go above that, then you have to have basically a tort kind of trial. So there's a certain amount of that. If the car that hit you belonged to a Tata company, they'd probably just give you a payment, an ex gratia payment, and that would be that. Actually, this ex gratia thing is really fascinating. I mean, there is this notion that people are entitled to something, or it's a good thing, but not necessarily that the injurer has to be held to account. And you can look up, if you go to the government of Delhi's website and look up, there's a long list of things for which you can get an ex gratia payment. If your house burns down, the government will give you so much. If you were injured in the anti-Sikh riots, back in 1991, you can get a certain amount. So there's a long list of claims that the government will give. So, depending on how you get hurt, there are ways, and I would say generally not very generous by our standards or international standards, but so ex gratia payments are, I'm sure, many more times more frequent than court recoveries. It's an interesting idea, and I wonder, those of you, how far back this idea goes. That it's a sort of, is this noblesse oblige that the big person who injures somebody, but here it isn't usually the injurer. The government of Delhi. I suppose you could say, well, if somebody's house burns down, it's because the fire regulations weren't being enforced or whatever, but I don't think they see that. They see it as a kind of largesse, a kind of benign, largesse, rather than meeting our responsibilities. But I think these are great topics that in India that nobody looks at is injury, what happens to people who's thought to be responsible, whether causing the injury. I mean, if one looked at, say, all these terrible, say, stampedes at religious festivals and so forth and so on, and that's a thing. Every year there are a number of these, and lots of people get killed. And typically, the government will just make some kind of an ex gratia payment. We'll announce we're going to pay so much to all the victims, and that's it. No one would say go after the temple managers who say failed to put up railings or whatever, failed to sort of manage the crowd and so on. Yeah, Mark.
So several decades after Bhopal, if a Bhopal were to occur again in connection with foreign investment,
Yeah.
do you think we'd see the same pattern circling through the United States through forum nonconvenience and then coming back into a settlement process in India? Do you think there'd be less confidence in that and therefore
Well,
let it circle out first?
It could be, although, it's interesting whether the U.S. court would send it back, given the history of Bhopal. And curiously, I should have to make a disclosure, I was the government of India's their expert on the Indian legal system when they were trying to keep the case here. So I was in effect hired by the government of India to badmouth the Indian legal system and say it was not an adequate alternative for it. It was a wonderful assignment. I really enjoyed it. What?
I do remember that.
Yeah. And so, but subsequently, there was a kind of little Bhopal case in which it was an Indian merchant ships. One of the perks of the officers is you can take your family on board. And so this happened, it was a ship, an Indian ship was carrying a cargo of wheat from Portland, Oregon, through the Panama Canal to somewhere. And when they went through the Panama Canal, they were in the Caribbean, one of the officers held up this child of another officer and to see something, but there was a spinning compass with a sharp blade, and the kid put her hand in it and got severely injured. They put her off, and she and her mother went to New York. I think there were some relatives in New York. They went to New York, and the little girl was treated. She then, and then these people went to a lawyer, and because it was a ship, ships, the way you sue a ship or sue the owner of a ship is you seize the ship, and then the owner puts up a bond, and the ship can sail on. So, and since the comings and goings of ships are more or less public knowledge, a lawyer tracked this ship down, and a year later it called in Philadelphia, and he went down there and they seized the ship and they put up the bond. And so this case for this little girl's injury on the Indian ship was against the shipping line was in Philadelphia. And of course the forum nonconvenience motion came up, and but this time we pointed to Bhopal and we said, look, even this big case of enormous public interest couldn't avoid the delay and so forth in India. What can this poor little private case expect? And the court said, you're right, and rejected the forum nonconvenience motion. So the case was here in the U.S. We were suing them. It went on appeal to the Third Circuit Federal Court of Appeals, and the court said, that's right, it can stay here, but you can only have Indian damages, damages at Indian levels. So that's where the law stands right now. We don't know what maybe the Indians would be bolder. At the time, they were very hesitant. They were afraid. Once the case went back, they said, if we make any changes in our procedure, Union Carbide, we can get the judgment. But then, after all, the money's in the U.S. So then we have to take the judgment and we go to the US where the Union Carbide has the money, and we have to, what's called, sue on the judgment. And there's something called the Uniform Foreign Judgments Act, which says American courts, when a foreign judgment is brought, will issue a comparable American judgment if the foreign judgment was obtained with due process. So then the question is, well, you know, could they say there was some denial of due process and therefore the judgment should not be recoverable here? And so they were so fearful of that they didn't want to make any change. You know, I mean, people said, look, you know, set it up, you know, set up a special tribunal, do it fast, etc. Said, no, we got to do it in the regular courts. The only concession they made was they said, we'll have a regular court that has nothing else, you know, we'll make it the sole assignment of this regular court. But in the end, of course, it didn't get tested on the due process thing because of the settlement. So it's kind of a mystery. You know, there's some new elements here, and but I think I'm told that in a number of commercial cases, also the American courts have been denying forum nonconvenience motions, keeping cases here. So it's hard to say. You know, there was a particular history in this case of a new judge, a federal judge. The federal courts distribute their cases to judges by lot. So the judge who was picked for this was a new judge. He was actually had been a criminal prosecutor. He didn't have a lot of experience with civil stuff. He didn't really want to do this case. It's hard to know. But we'll see. I'm sure. Sure if we wait long enough, it will happen again.
Friends, it's a few minutes past 1. I want to respect those of you who have other commitments, so